All right, you just heard from the plaintiff in the case that everyone's talking about. It's gone all the way to the Supreme Court. The website designer who wants to start a business, repeat, wants to start a business to celebrate weddings, but doesn't want to work with same-sex couples in terms of a marriage website. And justices who are more conservative seem to be pretty sympathetic to the plaintiff's arguments. Let's talk about now with Ian Millhiser, senior correspondent for Vox, conservative commentator Carrie Sheffield, and Chris Geidner, editor and author of Law Dork. I'm not calling you one. I'm just saying that's what you are.
Please do.
Just so we're clear, everyone.
I've known this guy for a long time.
All right. Well, look, it's been corroborated. I don't say, okay? But listen, we just heard from the plaintiff. I had been dying to speak with her and understand her position a little more. One of the things she said that I thought was really interesting was the idea of almost she was a champion in her case for LGBTQ members of a community group who thought that they might one day be forced to create websites that were contrary to their own beliefs. And this idea of the free speech element being the ties that bind. What are your reactions to what you heard just now?
I mean, I think that the case that we heard at the Supreme Court was a case to have an exception from a non-discrimination law. And we don't do that except for under very narrow circumstances. And this was a case that could potentially just blow that open.
What I find interesting, I want Ian just to put a fine point on this. People are probably wondering, I'm sorry, she's not in the wedding business yet. She does not have a wedding website business yet. The word yet, problematic.
Yeah.
How is it that the Supreme Court entertains more broadly the idea that, look, because somebody is prospectively going to be affected by a particular law, they have that level of standing that lawyers are always like, you don't have standing, you shouldn't be here. Why is she able to get before the court on this?
I mean, the honest answer is she shouldn't be in the court right now. I mean, maybe in a few years she'll have a valid case, but the court isn't supposed to hear hypothetical cases. That's not what federal courts do. And the weird thing about this case is no one actually seems to disagree with her. Like, Colorado filed a brief where it said, we don't want to make you design a website that you don't want to make. You have a First Amendment right not to design a website that you don't want to make. The only thing that Colorado says that its law does is if she makes a website for a straight couple and then a gay couple comes along and wants the exact same website, like literally the identical product, then their anti-discrimination law would kick in. I don't think that's likely to happen.
Well, she said she's a custom web designer. So that wouldn't necessarily happen in that instance.
So cases don't get to the Supreme Court without standing. So we have standing because the long arm of the government, in this case, the state of Colorado, has come in and said, you web designer, you will be suppressed. Your free speech will be suppressed. That's what this is really about. It's a First Amendment issue. And it's not just about LGBT issues. It's really about any sort of issue. For example, if you had a baker who was a Muslim baker, should they be compelled by the long arm of government to put a Muhammad cartoon? No. Do you think that's true?
So that's the issue that one of the many analogies. One was also about the idea of, in terms of, should a Jewish baker, for example, be forced to have in some sort of embroidery or recognition of the cake something that would be a neo-Nazi symbol of kind. So I hear the analogies, but here's, I think, the rub for a lot of people looking at this, and that is, they really weren't talking in this court about the religious aspect of it. They're talking about the free speech, which I know you're talking about. But I'm wondering about that slippery slope and just one of the many analogies we've all been hearing today and weeks before about where is the line? Where does it stop? At what point can someone say, oh, I'm not a bigot, I'm an artist, so I can do what I want?
I mean, this is the problem with this case, and this is why we haven't seen cases like this before. We've had non-discrimination laws for a long time. And the problem with the argument that you have in the case and what we saw today from Justice Jackson, from Justice Sotomayor, from Justice Kagan, is this idea, and Justice Sotomayor just came out and said it at one point, where is the line? And the fact is, there isn't a clear line. And Kristen Wagner, you had her on. In response to questions that she got at the court, she made it clear that line isn't clear. And the truth is that if you have this case decided the way that it looks like it's going to be decided, what's going to follow is people who have any number of arguments that what they're doing should be protected as a First Amendment, an expressive activity, and they don't believe that they should need to send X message.
And I think that that's what the Constitution is for. The First Amendment says that the government shall make no abridgment of freedom of speech.
And the great thing is
that
no one disagrees with you.
Hold on, I want to hear from all of you. Carrie, finish your point. Go ahead, excuse me.
Yeah, what I'm hearing is that you're afraid of people giving free speech. And I just don't think that that's something that the founders wanted us to be afraid of, or that anybody should be afraid of.
That's not what I heard him say, but I do hear your point that I've heard this argument be made. But Ian, the idea here of how this happens, I mean, let's play devil's advocate, for example, on this notion, and on the notion of, well, hold on, this is a business owner, right? She wants to have discretion over what services she has to perform. How is she similar or different to, say, a restaurant, which is what people say? You know, it's an artist saying, I don't want to do your portrait. I want to have discretion. I want to say who, I want to say when, I want to say who not.
Yeah. So let's play this out. So if she were to design a website, which she has not designed any wedding websites, if she were to design one, and then the Colorado government were to come after her, which it has not done, and say, hey, you are discriminating. And she said, well, wait a second, I have a First Amendment right to not make any website that I don't want to make. She would be right. If all of those events played out, then she would win her case. None of those events have happened, but if they happened, she would win her case. And what makes this different from a restaurant is that a website actually is speech. I mean, a website is a place where you put words on a screen. I write for a website, that's free speech, is protected by a First Amendment. Baking a cake is not speech. You know, making macaroni and cheese is not speech. You know, all of these other things, you know, making jewelry, being a hairdresser, all these other services that go into a wedding, not speech. Website, speech.
But it is expression, right, as a form of art. And so how does that factor in? That's probably your point you're going to raise.
Exactly, and that's she's not making widgets. And she even said she has clients who are LGBT, and they do other issues that are not specific to this issue. So again, the government cannot compel speech. The Supreme Court has never ruled on the side of suppressing artists. The Supreme Court has never ruled on the side of suppressing free speech. And so that's why they're going to win. I mean,
we don't disagree on that point. I think that they're going to win.
Yeah.
I think that the problem here is, and why we're having some of these difficult conversations, is there is no website. We don't know what to talk about. We're talking about these vague things because she hasn't made a website.
Why'd they take this case?
And so, because they want this law. They want this court to write this opinion that will potentially have these follow-up cases. I mean, they even said in court today, Kristen said, I might be coming back with a specialty baker. And then what you're going to find out, I mean, we've been talking about all of these lower court judges who go further. You're going to have somebody who says, I make very special macaroni and cheese.
I used one example of mac and cheese.
We're just gonna keep bringing it up.
I must have heard it in my back.
I love it. Now you want my mac and cheese. I get it.
They're going to do
I do want your mac and cheese.
First of all, but we're gonna be in court, and you're gonna have an opinion from Reed O'Connor down in Texas, and he's gonna say this is expressive speech. This is exactly what they were trying to protect in that case, and so I'm gonna say that you can't be forced to do that.
Well, let me tell you something.
I just think marriage is not macaroni and cheese, and I think that that's a pretty easy distinction to make.
Well, but macaroni and cheese is a website.
Yeah. I mean, I think
I don't think so.
there's
It's a
easier
website
distinction
about
to be drawn
marriage.
here.
It's a website about marriage.
Hold on. I want to hear everyone, so let's not talk over each other. Go ahead.
Yeah, so I mean, there's a really easy distinction to be drawn here. Words on a website is speech. If she wants to make a website, and if the Colorado government in the future tells her that she has to make a website she doesn't want, then she has a fine case. Websites are unlike mac and cheese. They're unlike cakes. They're unlike all of these other things. And so, I don't think there has to be a line drawing problem. Now, I share Chris's fear that with this Supreme Court and its Republican majority, that they're not going to draw the line in a sensible place. But there's a very sensible place to draw that line. Websites are speech. Macaroni and cheese isn't.
Well, I'll tell you, we can't look at it in a vacuum, right? There was the Dobbs decision where Justice Clarence Thomas did intimate that he wanted to revisit certain portions of things that are similar to this more broadly in same-sex marriage. So it's not as if this can be looked at purely in a vacuum, but we will see. And I'm going to have to put on Instagram my mac and cheese recipes because I don't know. I feel like I'm getting ready to open a restaurant right now. But don't worry, everyone is welcome to mine.
Thanks.
Look, everyone, next it's Warnock versus Walker.